This is Barry Zalma speaking for ClaimSchool Incorporated's blog, Zalma on Insurance. Today we're going to talk about why an arsonist must serve his full sentence and why it is chutzpah, or unmitigated gall, for a serial arsonist and insurance fraudster to request a shortened state sentence because he couldn't make as much money as he should while on home confinement. And he got absolutely no empathy from the court. Arson for profit, to me, is the most evil form of insurance fraud, where people may be injured or die. Defendant Michael Thomas set fire to many properties in a mobile home park and then used the mail to collect insurance money. He was charged with 4 counts of mail fraud, went to trial, and the jury convicted him on all counts. The court sentenced him to below guideline sentence of only 90 months of imprisonment. His sentence is set to expire on February 11, 2025. Mr. Thomas is currently under home confinement under the CARES Act. In United States of America versus Michael Thomas, the United States District Court for the Northern District of Indiana on June 6, 2024, noted that Mr. Thomas, proceeding pro se, moved for a reduction in his sentence, and the court considered his claims and rejected them. After serving time in prison, Mr. Thomas was released by the Bureau of Prisons to home confinement under the CARES Act to finish the rest of his sentence, which is expected to end next February. Mr. Thomas claims that the Bureau of Prisons is prohibiting him from securing employment as a pilot, a job which he held before being convicted of the fraud offenses. He states that he needs this job to maximize his income in order to repay restitution, support his family, and repay his student debts. Mr. Thomas insists that his inability to work because of home confinement constitutes a typical circumstances warranting compassionate relief. The court noted that the legal standard with regard to compassionate releases is that a court cannot modify a sentence once the sentence has been imposed, and an exception to that general rule allows a court to modify a sentence after considering if extraordinary and compelling reasons warrant such a reduction. The reduction is consistent with policy statements issued by the Sentencing Commission. The analysis proceeds in 2 steps when a court considers a request for compassionate release. At the first step, the defendant must identify an extraordinary and compelling reason warranting a sentence reduction. If the defendant establishes such a reason, the district court, in the discretion conferred by the statute, may consider the request. The defendant's rehabilitation is not by itself an extraordinary and compelling reason. For 4 years, Mr. Thomas was engaged in mail fraud schemes against insurance companies. As part of those schemes, he and an associate caused 7 fires at various dwellings in North Judson, Indiana. After the fires, he filed for and collected insurance payments on 4 properties that were damaged or destroyed by the fires. Of the 7 fires, 2 of them were at vacant properties set to deflect suspicion from Mr. Thomas's insurance fraud. By setting fires to residences, Mr. Thomas displayed no regard for the welfare and safety of those who lived nearby. While the dwellings he burned may have been unoccupied, his actions put first responders directly in harm's way, and there was no guarantee that the fires would not spread to nearby occupied houses. The nature of Mr. Thomas's criminal conduct, the need to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment for the offense, as well as the importance of deterring insurance fraud, among other factors, outweigh any mitigating circumstances in favor of early release. The court concluded that Mr. Thomas did not establish an extraordinary and compelling reason for modifying his sentence, that Mr. Thomas has a limited ability to do other jobs rather than his preferred one, due to his home detention status, does not convert his situation into an extraordinary one. There's no compelling reason to modify his sentence, and therefore Mr. Thomas's motion for compassionate release or reduction in sentence was denied. In my opinion, a professional pilot acting as a serial arsonist and insurance fraudster deserves no empathy. He was convicted of the violent and dangerous crime of arson for profit and served some time in prison, and was lucky and allowed to serve the remainder of his sentence at home, and then with unmitigated gall, true chutzpah, complained that the home confinement prevented him from making more money as a pilot, and asked for his sentence to be reduced. The court had no empathy. The court, as should every court faced with a serial arsonist, required him to fulfill his full sentence. It couldn't happen to a nicer person, and the sentence, in my opinion, was too short. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you subscribe to the blog, you can receive notice of every blog posting, usually 5, sometimes 6 a week, and also gain access to the more than 4,800 blog postings. You can also subscribe to the videos on YouTube and rumble.com. They're free. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.